Conversation with you today. In case you haven't joined us before, the idea of the Conversations with ICC Australia series is to meet once a month with the members of the ICC Australia community to exchange ideas, to share insights from our different experiences and even the jurisdictions that we're working with. Today we're very lucky to have with us Sean, Marriot, and Lara Hammoud. Sean and Lara are both here based on their experience in the ICC working group on expedited procedure provisions. Lara is a co-chair of the working group, and Sean is a co-lead on the interim measures track. And today they're going to be helping us to look at what issues are raised by interim measures in expedited proceedings and how you can address them. So Sean is a partner at Holman Fenwick Willan based in Perth, and Lara is an arbitrator at Arbitra based in Abu Dhabi. And they're both going to share their insights with us today, and I'm going to hand over to them to do so. And we will reserve some time at the end for some questions. So you can type your questions in the chat already as they come, or we will also prompt you at the end to pose any questions to the speakers directly. Thank you, Sean and Lara, over to you.
Thanks, Emily, and thanks to ICC Australia generally for putting on these great events, which I think many others are very grateful for the opportunity to participate in and to draw on the knowledge and expertise of an increasingly sophisticated Australian international arbitration community. So on to our topic for today. The first topic, essentially starting by looking at the big picture, the overall picture, Lara, what do you see as the difference between regular international arbitration and expedited arbitration?
So, hello everyone. I also want to say that I'm very pleased to participate in this episode and to meet Australian practitioners. I would start, Sean, by saying that expedited arbitration has gained attraction in recent years, and that's in response to the length and the costs of traditional international arbitration. And today, most leading arbitral institutions have adopted those specific provisions for expedited procedures in their arbitration rules. So the Institute, for example, introduced the expedited procedure in 2021 and defines it as a streamlined and simplified procedure with a shortened timeframes, which makes it possible for the parties to reach a final resolution of the dispute in a cost and time effective manner. The ICC has introduced in 2017 those expedited procedure and defines it as a streamlined procedure with reduced scales of arbitrators' fees, aimed at increasing efficiency in the resolution of the dispute. So, the common features and the differences with the regular arbitration is that usually you have a sole arbitrator instead of arbitrator 3, even if the parties had in their agreement agreed to 3. The ICC rules, for example, grant the authority or the power to the court to decide to have one arbitrator. They are also simplified procedures, and that's very important. There's a discretion that is given to the tribunal to simplify the procedures in a way that there is limited round of submissions, possible no document production, no hearing. Again, a simplified procedure, and even the final award, some rules would, allow that the award is either not reasoned or very with summary reasoning, and hearings may not be held. So generally, it's less expensive, and depending on the rules, they are usually opt-in or opt-out. Now, I'll finish with just some statistics, since Emily referred to the working group. Although we cannot say much yet because the report is not issued publicly, but what we can say is that we've looked at 341 cases since the beginning of the EPP. And we've noted that in those 341 cases, there were only 18 where there have been expert reports, and 70 where there has been document productions, and only 190 have had short hearings. But among those 190, there's a 121 that were hybrid. We also noticed that the awards were generally delivered on time. So I'll stop here. I know the time is limited. I'm my turn, Sharon, to ask a question now. So what do you think that the use of expedited proceedings by parties are likely to grow in the future based on everything I've said?
I think it's worth starting with a little bit of history, and then to project forward. The introduction of expedited procedures stemmed from a consensus or a growing realization that the time and cost associated with arbitration were becoming unduly burdensome, or more burdensome than they had been. For example, the ICC was treating all cases on the same footing, so the same set of rules applied for all disputes, irrespective of their value and complexity, whether they're valued at under $1 million or over $1 billion, which is in a sense the opposite from a tailor-made proceeding that is proportionate to the amount in dispute. However, the background is that around 40% of the aggregate ICC caseload concerns arbitrations with claims valued at less than $4 million. So there's a lot of cases at the lower end. And while the ICC rules do give tribunals and parties the inherent flexibility to streamline their proceedings on the merits, there was no default set of rules for resolving cases in a shorter timeline and a lower complexity. So the ICC's expedited procedure filled that need. Now, as you mentioned, it was first enacted in March 2017, and then and at that stage it applied to cases with a value up to $2 million with opt-ins for other parties. Then in 2021 the cap was raised to $3 million for arbitration agreements entered into after that date, and again with optional opt-ins for other parties. And it's been popular. The expedited procedure, the ICC expedited procedure has been popular since its introduction. There have been a total of currently around 713, probably more by now, expedited procedures have been conducted, and 2023 saw the high watermark of 189 new expedited procedure cases. And I think it's fair to say it's been successful because it focuses and incentivizes parties to work towards a short, compressed procedure. And so the ICC's response to the level of interest in expedited proceedings has been that in March 2023, the ICC Commission on Arbitration and ADR announced a new expedited procedure working group. And as part of its mandate, the working group was asked to review and report on the experience of expedited procedures conducted to date, with a view to drawing lessons from emerging expedited procedure practice, and to present its conclusion to a wide audience of in-house counsel, external counsel, arbitration practitioners, arbitrators, and the wider arbitration community. And secondly, to prepare a concise guidance note to be used as a toolkit for expedited procedure arbitrators to fill in the gaps where the rules didn't give them relevant guidance. And also to prepare a fact sheet to promote expedited procedures and to mark the filing of over 700 expedited procedure cases, and also, of course, to recommend potential improvements to the existing expedited procedures. And the Commission is due to report in 2025, and as Emily mentioned, Lara and I are both involved in that process as members of the working group. So there's no doubt that expedited procedures have been popular, and they're growing in their use. And I think it's fair to say with the sort of complexity of energy transition type arbitrations coming up and the multiplicity of parties being involved in those dispute proceedings, it's likely that they'll be used a lot more in the future. So that's that on that topic. So moving on to the next subject, Lara, what do you see as the purpose of interim measures generally in international arbitration.
Yeah, thanks, Sean. So interim measures, constitute an immediate and temporary relief, as we all know, that is aimed at safeguarding a right or an asset pending the determination of a case on its merit. So it includes measures to preserve the status quo or prevent, dissipation of assets before a final award is issued. So it is, a strategic new tool that needs, in my view, to be considered carefully, but it is useful to protect a party's rights in arbitration proceedings, and is generally available upon the application to the tribunal or to the courts. So it's kind of either or. And the arbitral tribunals are granted the authority to issue interim measures by arbitration rules, so the parties' agreement to those rules, or by arbitration laws. And as we all know, in the ICC rules, it's Article 28 that grant the tribunals, that right as soon as the file is transmitted. And it gives, as we will see, a large discretion to the tribunal to render those interim measures. Now, the question to you, Sean, is, how are such interim measures granted? I said that they can be granted by tribunals or courts. Could you say a bit more on that?
Yeah, well, the short answer is that interim measures can be granted by courts or in the same way as they're granted by tribunals in regular arbitral tribunals, as courts and tribunals frequently have concurrent jurisdiction for that purpose. Depending on the lex arbitrae, courts can provide an alternative source of interim relief for a party. In particular, court applications for interim relief are permitted, expressly permitted under many arbitral rules, including UNCITRAL, ICC, LCIA, and so on. Although those rights may be qualified in some cases. Interim measures can be granted in the form of an interim award as opposed to a partial award on merits issues, and they can arguably be seen as in that sense as finally disposing of the request for that relief, and so on that basis being recognisable and enforceable by national courts. The power of the tribunal to order interim measures is also now generally accepted either expressly in national arbitration laws or considered as part of the tribunal's inherent powers. So I think that gives rise to the question of which should be used, tribunals or courts. And more broadly speaking, whether to grant an interim measure requires an evaluation and balancing of competing interests of the parties in the context of of an expedited procedure. One such interest is the expeditious resolution of the dispute via the expedited procedure, and another is the need for adequate due process and the parties' right to a reasonable or full opportunity to present their case. If expeditious resolution is given too much weight, then this can potentially result in a blanket exclusion of interim relief and expedited procedures, and parties would likely then respond by filing court applications for interim measures, which would not support the objective of achieving expeditious dispute resolution. Also, some forms of interim relief are only effective if issued by courts, and parties shouldn't otherwise need to go to court because the arbitral rules limit the relief options. And in any event, the final decision on whether to apply for to a court or a tribunal for interim measures should be a strategic choice for the parties to make, because forcing parties to resort to different fora for different types of relief is arguably inconsistent with another expedited procedure objective, which is the simplification of the procedure. And also, in many cases, an expedited procedure tribunal is much better placed to decide on the form of interim measure by tying its timing and validity to the issuing of the final award within the 6-month deadline. So it's important for interim measures to be available in expedited procedures so that courts do not conclude erroneously that the parties have agreed to entirely forego those measures in return for expeditious resolution. That said, in some jurisdictions, courts only have jurisdiction if interim relief is not available from tribunals, which may be the case in expedited procedures for, say, preliminary evidentiary measures. So while tribunals generally have the power to grant interim measures, fettering parties' access to those to interim relief from courts is also undesirable, as arbitral and curial interim relief differ in scope, enforceability, and may be complementary. So I think that's sort of the sort of overall view on that I'd put forward. Moving on to the next topic, do arbitral institutions' expedited procedure frameworks generally provide sorry, have I jumped to the wrong question there? Oh, sorry.
No, it's my question to you. It's my question to you. But the question was basically if, is whether, the institutions, EPPs provisions, expedited procedure provisions, generally provide prospective rules for granting interim measures, or is usually the decision left to the tribunal discretion. So, how is the decision basically taken by the tribunals?
Yeah, I think the general approach is that the rules tend to be permissive rather than prescriptive, which is obviously important given the tight timeline and constraints that the tribunal will be working under and the resulting need and desirability for flexibility. Generally, tribunals' inherent jurisdiction is arguably sufficient basis for interim relief anyway, where the tribunal deems it appropriate. And in order to minimize challenges, tribunals are also likely to decide applications based on the usual considerations, including irreparable harm, reasonable prospects for success on the merits, balance of convenience and damages being an inadequate remedy. As to the individual institutions approach, again, generally permissive as opposed to prescriptive. The ICC expedited procedure doesn't specifically provide for interim relief, but Article 5 says that in all matters concerning expedited procedure not expressly provided for, the court and arbitral tribunal shall act in the spirit of the regular rules and the expedited procedure itself. And the regular rules provide for interim relief in Article 28, as you've mentioned, which allows the tribunal to order any interim measure it deems appropriate at the request of a party, with any security it deems appropriate in the form of an order or an award, and of course with reasons. And the rules don't restrict the right of parties to apply to courts for interim measures as well. The SIAC expedited rules also don't expressly provide for interim measures, and so tribunals can follow the ordinary rules on interim relief, which provide the tribunal may, again, at the request of a party, grant any interim relief it deems appropriate in an award or an order, and again, it doesn't preclude applications to court. Similarly, with UNCITRAL rules, they don't expressly provide for interim measures, but the ordinary rules obviously do, and they will likely be relied on. An exception is the AKICA expedited procedure rules, which do expressly provide for interim measures of protection in Article 24, and they permit the arbitrator in appropriate circumstances at the request of a party to order interim measures in an order or award with reasons and optional security, and it specifies the criteria for doing so. And that allows for the usual measures, such as maintaining the status quo, avoiding imminent harm, preserving assets, evidence, and providing for security of costs. So generally, the approach is a permissive one, but there are the KICA and perhaps some other institutions which are adopting a more structured approach. So moving on to the next topic, Lara, if granting interim measures is discretionary, what are some of the considerations that tribunals should take into account in deciding whether to grant such measures?
Yes, I think, as you said, Sean, usually the rules are, grant discretion to the tribunal, and we can discuss later if we have time whether this is good or bad, or do we prefer permissive or or prescriptive rules. But Article 28, as you said, it gives that discretion to the tribunal, and in expedited procedures specifically, there are, as we said earlier, those competing interests between, the expeditious resolution of the dispute, which is the priority, but also the right of a party to seek interim measures from tribunals. And we know that interim measures applications may require time and cost. So it's kind of a competing interest between, the objective of the interim measure. So the question is, to what extent interim measure should be limited in EPs, or alternatively, one can think that, as you said, Sean, an EP tribunal, expedited procedure tribunal, may be better placed to fashion the form of interim relief in the, in an EP in expedited procedure, because they will time it to that expeditious timeline of 6 months. So having said that, with that in mind, there are some specific considerations to take into account when tribunals are using that discretion we discussed to order interim measures, applying, the usual balancing of factors. And some of the considerations are obviously, due process. Due process is the challenge, as I said, in EP. Because you do need to, despite the streamlined procedure, you need to give the parties equal opportunities to defend their positions. So it's a fundamental requirement for enforceability, but also the application depends on the context. So, just in terms of example, the tribunal may want to fashion the briefing on the interim measures to rebalance the fact that the applicant will generally have had more time than its opponent, to prepare, and then the other to respond. So these things are, these kind of timelines and considerations need to be taken into account to be able to give both the equal opportunity to say what they have to say on the application. There are some other considerations, which is obviously the whether to hold a hearing or not on when it comes to the application. So obviously sometimes it's faster and you may save cost when you have a quick call with the parties on to discuss this application rather than having written submissions, etc. So you may want to consider that. The timing, what is the latest time that an application can be made? Do we want to have a deadline? But this is taken into account because the later this application is raised or submitted, the more difficult, the decision would be in terms of abiding by the 6-month, deadline of an EP. So those are consideration trends that I can think of, but I think you have more to add. I see someone, Duke, raising his hand. I don't know, Emily, I'll leave it to you whether we take questions now or we leave it to the end.
I think maybe we have Sean's last question, and then Doug, we'll turn over to you if that's all right.
Okay. I think carrying on from where you left off, Lara, there are a few other considerations that tribunals should take into account when determining whether or not to grant interim relief in expedited procedure, expedited proceedings. The first one is urgency, and while urgency is not necessarily a threshold issue for interim measures, aside from in emergency arbitrator proceedings, urgency is inevitably a relevant consideration from a practical standpoint when balancing the parties' interests in expedited procedures, given the arbitrator's obligation to issue the award within 6 months. So the decision on urgency is best left to the tribunal's discretion, taking into account factors such as whether the measure can await the final award, which of course will usually occur considerably faster in expedited proceedings than in regular proceedings, whether the application has been made promptly, on the applicant becoming aware or when it ought to have been aware of the need for the application, again, given the compressed timeline, and whether the application will delay the award beyond the 6-month time limit. Another consideration is the type of measure, and the decision may vary based on the impact of the measure. There's no reason why the usual forms of interim relief should not be available in expedited procedures, as well as potentially other forms of interim relief, for example. And some of the ones that have been discussed have been things like under the Dutch emergency arbitration proceedings, interim measures can provide binding determinations of issues, albeit subject to a final decision by the tribunal on the merits. On the other hand, there are some good reasons to limit interim relief and expedited procedures to only those measures that are compatible with expedited procedures. For example, pre-action document production or other preliminary evidentiary measures used to assess merits prior to commencing proceedings are probably unlikely to be compatible with an expedited procedure where the imperative is time. And the type of measure is also relevant in deciding on the timing and form of remedies. Different considerations apply to different measures. For example, preservation and inspection remedies, such as injunctions or orders for preservation or inspection of property, generally require consideration of the cost and time impact of that measure. Security of cost applications are a bit different. They require consideration on the level of anticipated costs, as well as the usual security of cost considerations, but timing is less of an issue, as an order is unlikely to significantly impact the procedural timetable. And then the form of the measure and its enforceability timeline also need to be taken into account. The form of the measure will determine its enforceability or influence its enforceability, and may vary per jurisdiction, depending on whether the measure is in the form of an order or in an award. An interim measure in the form of an order is likely or may be completed faster, but it is likely to be less enforceable. On the other hand, an interim measure in the form of an award may encounter enforcement challenges based on, for example, an alleged lack of finality. However, this can also depend on the subject matter. For example, if an interim measure contains a final ruling or a ruling on a contractual issue. And also making a decision in the form of an award can potentially impact the timing of scrutiny before the ICC. So a compromise can potentially be to combine both approaches, where a tribunal combines both approaches and make a provisional order and then enshrine that in an interim award. The logic being that it preserves the best aspects of both methods, especially the speed of an order combined with the enforceability of an award, particularly where institutional scrutiny is required. And the last point I think needs to be taken into consideration is reasons for the decision. Notwithstanding the need for expeditiousness, where the applicable law or rules require any decision by an arbitral tribunal to be reasoned in order to be enforceable, then an award of an interim measure in expedited procedures must also be reasoned. It's theoretically possible, especially where the need for relief is urgent, for tribunals to issue the decision in an award initially without reasons, with reasons to follow later. But obviously there are disincentives to that because it comes with significant risks of a challenge based on the lack of reasoning and invalidity of the award. And also such awards would potentially breach arbitral laws, as well as the ICC rules, for example, which expressly states the need for reasons. And in any event, in most jurisdictions, awards must be reasoned unless otherwise agreed by the parties. National laws as well as arbitral institutions require this, and a good example is the model law, which requires reasoned award as the default requirement, unless the parties agree otherwise. So if an interim measure is made in an award, the award effectively in most cases must be reasoned. It's also important to note that the requirement for reasons is not an opportunity for a substantive review of the award. Reasons can be high quality, they can be low quality, but if they're in there, the box is likely in most cases to be ticked. I'm sure there are exceptions to that, but generally speaking, that's probably correct. Another thing that tribunals can do is potentially include some guidance in their initial procedural order as to how they will deal with applications, and that may disincentivize unmeritorious or speculative applications. But of course, everything they put down in that in their procedural order may be used as a ground for challenge. So I think there's a lot of things to think about in the process of determining whether interim relief should be granted in the course of expedited proceedings.
Thank you so much,
Thank
Lara
you.
and Sean. And this was super interesting. Doug, did you have a question or a comment that you wanted to put to the speakers?
I realise we're out of time, but I just wanted to ask whether either have the statistics on applications for emergency arbitrator relief in the ICC expedited process.
So we, Sean, correct me if I'm wrong, but we haven't seen interim measures in the EPP. Have been, yeah. So that's what we concluded, but we do need to I think come with like final statistics. But for now, we haven't seen. We're not in a position to say actually that there have been any interim measures in those EPP.
I suppose yeah, I guess there may be a slight distinction, Doug, between interim measures and the emergency arbitrator. It may be that the statistics that Lara refers to was focused on the former rather than the latter.
Yeah, sorry,
was not sure on that.
Question on the latter. Sorry, I misunderstood.
I think Doug was referring to emergency arbitrator proceedings in the context of an expedited procedure. Is that correct, Doug?
Have there been, and how many have there been, applications for emergency arbitrator relief under the expedited rules?
I don't know.
All right, no, I don't know. Yeah.
That would be an eloquent statement of whether the speed of formation of the tribunal under the expedited rules obviates the need for emergency arbitrator relief under the ICC rules.
Right.
Great question.
To be looked at.
I'll have to come back to you on that.
More work for the working group. Do we have other questions?
What's the typical value of the expedited procedure arbitrations that you've seen?
They're typically up to, I mean, the threshold is $3 million, but there are opt-ins. And one potential use of expedited proceedings for potentially much larger cases is to use it as an enforcement mechanism of dispute board decisions, where there's a contractual determination, but it's not necessarily enforceable. That can then be taken to an expedited procedure for a relatively quick ruling, and used as the basis to procure an award. So I don't know what the typical or the mean or the median level of the disputes, but most of them are within the 3 million threshold. But there are exceptions, and yeah,
there have been some that have been way like I think there's one with like a few 10 or 20 million or even higher, but those are the parties obviously who had decided to revert to EPPs, but as Sean said, is mainly below 3 million.
The real attraction of these is for low value disputes. So people just go straight to the point and forget about all the interim stuff. Just get to a quick outcome. That's all they care about, isn't it?
It may be. I think that that's exactly right. But when they find themselves within the proceeding and then something happens, there's an event which they don't like, they may decide that their view shifts. And if they think that the other party is hiding a key piece of evidence or something along those lines, then that can be the motivator. But I agree. I mean, if parties are happy to go into an expedited procedure, they won't be foreseeing using interim measures, or unlikely they would be.
Any other thoughts from the audience in our bonus time? Well, I think we are out of time, but Lara or Sean, did you want to add anything else before we sign off for the day?
I pose a final question to Lara. From an in-house legal perspective, given your extensive experience with ADNOC and elsewhere, are there any particular considerations that parties, as opposed to their representatives, should focus on when considering whether to apply for an interim measure?
Well, thank you, Sharon, for your last question. Very briefly, listen, when you're, I think, especially in the oil and gas sector, where I spent 10 years until very recently, disputes may involve, significant financial stakes or operational disruptions. And you do need to consider whether an interim measure could help avoid the harm you think you will be caused. And obviously you need to look at many factors, such as, whether there's an immediate threat, is there a irreparable harm, and what's the enforceability, of an interim measures like. But also, from a business perspective, you do need to look at the long-term strategy. You want to consider how the request aligns with the overall legal strategy and, more importantly, business objectives. And you also want to balance, make sure that whether the benefits of getting the interim measure outweigh the potential negative impact on the other party, who may be your partner had been your partner for a long time and who may continue to be. It's really on a case-by-case basis. I would say, to conclude, that having spent time in NOC for a long time, I think the top priority where an interim measure could really be considered on a case-by-case basis is really when you have a risk on the production. We all know that one day of exploration is worth hundreds of millions of dollars and can cause a lot of disruption to the supply chain, etc. So production is key, and confidentiality with all the the data and everything that is linked to techniques, drilling, etc. can have confidentiality is very important. So that's something that can trigger a real consideration. And obviously the reputational damage that is very often linked to environmental issues. So I would say those are really important risks where an NOC may consider going for interim measures, again on a case-by-case basis. But Emily, just to thank you, just to also say a few words. I just wanted to thank you for inviting me, but also to say that the working group is submitting the report to the ICC Commission for approval in April next year at the ICC Commission. And so it should be then obviously available to the public for those who haven't read the draft yet.
Fantastic. We very much look forward to that, and congratulations to you both for all the really interesting work that you've done on the working group. And thank you for sharing some of the issues with us, even if we can't yet read the final product. But it's a good sneak peek. And thank you everyone for joining us today. And this was the last episode of Conversations with ICC Australia for 2024. And we'll obviously be arranging new episodes in the new year, and we look forward to having you again then. And thank you very much again to Lara and Sean for joining us and for your time.
Thank you all. Thank you, Sean.
Thank you.
Thank you,
Lara.
Emily.
Thank you, everybody.
Bye-bye.
Thank you, everybody. Just to see you. Bye.